This sentencing hearing isn't about whether Eric Cox made a mistake. It's about whether the system can afford to give him another chance. What brings him before the court today is staggering. This is his 7th OVI. Not his 2nd, not his 3rd. His 7th. And even more alarming, this offense happened while he was already on probation for another OVI. The state is asking for prison time and a lifetime driver's license suspension, arguing that public safety has to come first. Probation agrees. The defense doesn't dispute punishment. Instead, they ask for mercy based on something new. A recent diagnosis of bipolar disorder after more than 2 decades of being treated incorrectly for depression. That detail matters. Because the defense isn't denying responsibility, they're saying the behavior finally has a medical explanation. And now, possibly, a solution. Lithium. Stability. Accountability. But here's the tension. Mental health can explain behavior. It doesn't erase it. And when alcohol, untreated bipolar disorder, and repeated drunk driving collide, the consequences can be deadly. As you watch this unfold, ask yourself this: how many chances is too many when lives are at risk? Because today, this judge has to answer that question, not just for Eric Cox, but for everyone else on the road.
This is case number 25CR42737, the State of Ohio versus Eric Cox. Mr. Cox is before the court with his counsel, Mr. Perry. Ms. Tranter, on behalf of the State of Ohio, we are here for sentences. Tranter, anything on behalf of the state?
Yes, Your Honor. On behalf of the state, we are asking that this court impose a prison term upon Mr. Cox. I do believe that this is a serious safety. It's his 7th overall driving under the influence. My understanding is that he has 13 days of jail time credit, and this is a situation where I would be also asking for a lifetime driver's license suspension. Mr. Cox has proven that he has no regard. He was driving under an OVI suspension when he picked this one up. So I do believe that a lifetime ban on him driving is appropriate, and we would ask for an appropriate prison sentence as well.
Okay. Anything from probation?
The recommendation from probation is prison with potential judicial release, Your Honor.
Okay. Mr. Perry.
Judge, as strange as this sounds, we recognize that the court is going to punish Eric today. We recognize that it is very likely that he'll go to prison. But if he had his choice of local jail time, a CBCF, or DOC, he would actually ask the court for DOC so he can continue his bipolar medicine, which is lithium. And I'll also say this, Judge, I guess I'd ask the court to temper any punishment that is imposed today based on this. I can't stress the importance of this diagnosis in June, where at Recovery Refined, they actually realized that for the last 25 years he's been treated for depression, chronic depression, with antidepressant medicines that have only aggravated a bipolar disorder that was never diagnosed until the summer. So moving forward from this offense, the hope is, the expectation is, that this newfound diagnosis and his treatment with lithium may very well change how he responds in the future. We have very high expectations that these hypomanic episodes that often lead to Eric believing he can do things that he cannot do, but he still engages in that risky behavior. The hope is with this medicine, the lithium, those highs will disappear, and he will be the person he's always tried to be. Absolutely 100% compliant in the medications that the doctors suggest that he takes, and absolutely positively compliant with his recovery, because he knows full well that he is an alcoholic, and if he begins to use, he's only going to abuse the alcohol until he goes out into such a highly alcoholic rage, crazy things happen. So again, Judge, we realize what the court is about to do. We ask for some level of mercy, some temperament, some ability to temper the sentence, so that this expectation for his future can be realized sooner than later. He is supported this afternoon by his mother, by his fiancée. He is a business owner, a very successful painting business. These are things that he does not want to lose. He realizes he has a debt to pay, but he certainly would like to come out of the DOC sooner than later.
This is one of the rare moments where the defense openly acknowledges prison is likely, even necessary. That alone tells you how serious this case is. The argument here isn't don't punish him, it's don't give up on him. The defense lays out a compelling medical narrative. For 25 years, Eric Cox was treated for depression when he was actually bipolar. Those untreated manic episodes, combined with alcoholism, led to impulsive, dangerous decisions, including repeated drunk driving. Now, for the first time, he's on the correct medication. But listen closely to the judge's response. Compassion is there, but so is accountability. 7 OVs, high tier, back on probation at the time of the offense. Those facts carry enormous weight. Judges are required to consider recidivism, and this record screams it. The court isn't deciding whether Eric means to do better. It's deciding whether society can risk him failing again. So let us ask you, failing. Should a late diagnosis soften the sentence, or should the record speak louder than hope?
Mr. Cox, is there anything you'd like to say before I sentence you, sir?
Just simply that I'm sorry. I am really sorry, and I give account, and I'm ready to, serve my sentence as a man. I realize that I do deserve to be punished. I realize that Ed's told me before, they keep saying that they've given him kind of light sentences, and I've said, Ed, I don't disagree. And so I know that you're going to be a little bit more harsher, and I just want you to know that I accept that, and I deserve that. I do say also with that is, I'm sorry. I'm sorry that I've put you guys in this position. This is not the person that I want to be or the person that I am. And then with that, I think one thing that gives me a sense of hope is I do have some understanding of something else that's going on that may be contributing to this that I can now address. So this doesn't happen anymore. Because I don't want to behave like this. I don't want to hurt someone. Like, that's not me. And so I'm sorry, and I'm ready to pay the price. That's it.
All right, sir. Court's considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Mr. Cox, I get that there's a mental health component to this, and I'm certainly not I am certainly compassionate to the situation you find yourself in. And again, I don't intend to throw the book at you. I've told Mr. Perry that with having seventh OVI, with you being on probation at this time for the offense of OVI, when having committed this offense, having a high tier test above a 0.17, it's very, very concerning to me. And you go back and look at all your prior sentences, and you've always received the maximum mandatory penalty, which again, as an attorney, that's what you did to represent. But as a judge, as I sit here now, I do have to account for my decisions as well. I do appreciate the fact that you're accepting responsibility, that you're accepting your punishment. But again, my hope is that we get your attention to the point where we don't have this ever happen to you again. Or even worse, if for some reason that you would do it and hurt somebody. I mean, that would be, can you imagine how you would feel if you had hurt somebody in this?
I'm going to be able to live with myself, Your Honor.
So what I'm going to do is, on the OVI charge, I'm going to order you to serve 24 months in prison. You have 13 days jail time credit. I am suspending your operator's license for your lifetime. There is a fine of $1,370, which I do not have the authority to waive. Other than that, I am going to find that you're indigent for the purpose of fines, costs, or other financial sanctions other than that mandatory fine. And I did tell you, I told Mr. Perry, that it is my intention that I would grant you judicial release after you serve a portion of your sentence. Of course, there's a mandatory portion of this sentence that you have to serve, which is 120 days.
I think it's 122.
120.
120. So that you have to serve at least that long. But after that, I would be open to considering you for judicial release, and hopefully will have gotten your attention at that point in time. Does that make sense?
That makes sense, Your Honor.
All right. Again, I don't try to be harsh. We try to be realistic. I just was looking at something and.
Yeah, and again, I understand.
Okay.
I understand the predicament you're in.
Okay, so you are subject to a discretionary period of post-release control. So, and I'm required to tell you this. So, if you serve out your sentence, when you are released, the Adult Parole Authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If if your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, all of that can be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
Your Honor, you said the fine is $1,350?
I said 1,350, yes.
Okay,
Did I
thank you.
say something different than that?
I thought you said 70, and I may have misheard you.
I
but
did
it's-
say 70, because that's what I wrote down, but it's 3,350.
Correct.
Mr. Perry, is there anything else?
Nothing for the change.
All right, this time, Mr. Cox, there is a deputy standing behind you. I am going to remand you into the custody of the Warren County Sheriff for transport to the Department of Corrections.
The final sentence reflects exactly what this case represents, a line drawn between mercy and protection. The court orders 24 months in prison, credits time served, and imposes a lifetime driver's license suspension. That's not symbolic, that's preventative. The judge makes it clear, driving is no longer an option. But there's also a conditional olive branch. After the mandatory 120-day portion, the judge is open to judicial release, provided Eric Cox proves that treatment, medication, compliance, and sobriety are real this time. This sentence isn't about punishment alone, it's about interruption. Breaking a cycle before it ends in tragedy. Legally, this case shows how courts handle repeat OV offenders, escalating penalties, loss of driving privileges, and limited chances for early release tied to strict compliance. Now we want to hear from you. Was this sentence fair, or should a 7th OV, even harsher consequences? If you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns straight from the justice system.